difficult issues.
And Senator Hatch will get a 20-minute round of questioning in about 20 minutes or so. First up, though, Senator Patrick Leahy, the ranking member of the Judiciary Committee.
The hearings will resume. And turning to the distinguished ranking member, Senator Leahy, for 20 minutes.
Well, thank you, Mr. Chairman, and Judge Alito, welcome back. If past is any prologue, you probably don't have more than another day or so of this to go through, but I am concerned, and I want to just state this right, concerned that you may be retreating from part of your record. And I think that some of the answers, and I've expressed this concern, I mentioned to the chairman, I'm concerned some of your answers were inconsistent with past statements. And all of us want to know your legal and constitutional philosophy. So let's go back to the questions I was asking yesterday about checking presidential power. And we spoke about the Justice Jackson's opinion in Youngstown. Justice Jackson, as you know, is a hero of mine, and I point often to the Youngstown case. But when Congress acts to strain the president's power, as we did with the anti-torture statutes and the Foreign Intelligence Surveillance Act, I believe the president's power then is at its lowest ebb. You seem to be saying yesterday that fell into the second category of Jackson. That's the twilight zone. Actually, I believe you were mistaken on that. Justice Jackson spoke of the twilight zone area, or as he said, a zone of twilight, where Congress had not acted. So let's go to a landmark decision in Hamdi. Now, and Justice O'Connor's decision, that's whether there was due process required. A U.S. citizen can have a meaningful chance to challenge his detention by the government. Now, Justice O'Connor wrote that the president does not have a blank check, even in time of war. And yesterday you told Senator Specter that you agreed with Justice O'Connor's general statement. Now, a very different view was in the dissent. Justice Thomas would have upheld the extreme claims for this all-powerful and essentially unchecked president. He argued the government's powers could not be balanced away by the court, and there is no occasion to balance the competing interests. Which one's right, Justice O'Connor or Justice Thomas? They're quite a bit different.
Justice O'Connor wrote the opinion of the court. The first question that she addressed in Hamdi was whether it was lawful to detain Hamdi, and it was a statutory question. It was a question whether he was being detained in violation of what is often referred to as the anti-detention statute, which was passed to prevent a repetition of the Japanese internment that occurred during World War II, and she concluded that the authorization for the use of military force constituted authorization for detention. And then she went on to the issue of the constitutional procedures that would have to be followed before someone could be detained, and she looked to standard procedural due process law in this area and identified some of the requirements that would have to be followed before someone could be detained. And now issues have arisen about the identity of the tribunal that is to make a determination about detaining people who are taken into custody during the war on terrorism, and that's one of the issues that's working its way through the court system.
No, I'm not talking about the things that are working, but just on Hamdi, that has been decided. Would you say that Justice O'Connor basically applied the Jackson test, not the Twilight Zone test, but the test of where the president's power is at its lowest ebb?
In addressing the statutory question, I don't think she had any need to get into Justice Jackson's framework as well.
But would you say it would be consistent with what Justice Jackson said?
I think it certainly is consistent with Justice Jackson said.
Which decision do you personally agree with, hers or the dissent by Justice Thomas?
I think that the war powers are divided between the executive branch and the Congress. I think that's a starting point to look at in this area. The president is the commander-in-chief, and he has authority in the area of foreign affairs and is recognized in Supreme Court decisions as the sole organ of the country in conducting foreign affairs.
But you're not going to say which of the two decisions you
I'm trying to explain my understanding of the division of authority in this area, and I think that it's divided between the executive and the Congress. I certainly don't think that the president has a blank check in time of war. He does have the responsibility as the commander-in-chief, which is an awesome responsibility.
But and we all understand that, appreciate that. My understanding, listening to Chief Justice Roberts when he was here saying where you are, that he felt that Justice O'Connor's decision most clearly tracked the Jackson standards in Youngstown. But let's go. I want to get more into this unitary executive theory, because I really had questions listening to you yesterday. You've said, as recently as 5 years ago, that you believe the unitary executive theory best captures the constitutional role of presidential power. You were a sitting judge when you said that. And do you still adhere to that legal and constitutional view that you were expressing 5 years ago?
I think that the considerations that inform the theory of the unitary executive are still important in deciding separation of powers issues that arise in this area. Of course, when questions come up involving the power of removal, which was the particular power that I was talking about in the talk that you're referring to, those are now governed by a line of precedent from Myers, going through Humphrey's executor, and Weiner and Morrison, where the court held 8-1 that the removal restrictions that were placed on an independent counsel under the Independent Counsel Act did not violate separation of powers principles. So those would be applied. Those would be the governing precedents on the question of removal. But my point in the talk was that the considerations that underlie this theory are relevant, should inform decision-making in the area, going beyond the narrow question of removal.
But in the past, you criticized Morrison. Are you saying now that you're comfortable with Morrison?
Morrison,
accept it?
Morrison is a settled precedent, is a precedent of the court. It was an 8-1 decision. It's entitled to respect under stare decisis. It concerned the Independent Counsel Act, which no longer is in force.
So do you hold today that the independent counsel statute was beyond the congressional authority to authorize?
No, I don't think that was ever my view.
To enact, all right. Under the theory of unitary executive that you've espoused, what weight and relevance should the Supreme Court give to a presidential signing statement? I ask that because these are real issues. I mean, we passed the McCain, Warner et al. Statute against torture when the president did a separate sign, after he signed it into law. He didn't veto it. He had the right and, of course, the ability to veto it. He didn't veto it. He signed it into law, and then he wrote a sidebar, signing statement, basically saying that it will not apply to him or those acting under his orders if he doesn't want it to. Under a unitary theory of government, one could argue that he has an absolute right to ignore a law that the Congress has written. What kind of weight do you think should be given to signing statements?
I don't see any connection between the concept of a unitary executive and the weight that should be given to signing statements in interpreting statutes. I view those as entirely separate questions. The question of the unitary executive, as I was explaining yesterday, does not concern the scope of executive powers. It concerns who controls whatever power the executive has. You could have an executive with very narrow powers and still have a unitary executive. So those are entirely different questions. The scope of executive power gets into the question of inherent executive power.
Well, let me go into that a little bit, because back in the days when I was a prosecutor, I mean, I was very shocked what happened in the Saturday Night Massacre. President orders certain things to be done. The Attorney General says, no, I won't do it, fires him. The Deputy Attorney General said, okay, you do it. And Deputy Attorney General wouldn't, saying violate the law, fires him. They keep on going down. Finally, they find one person, person you've praised, Robert Bork, who says, fine, I'll fire him. I'll do what the president says. You have criticized Congress for allowing these independent agencies to refine and apply policies passed by Congress. You said that insofar as the president's the chief executive, he should follow their policies, not Congress. So let me go into, let's take one, for example, the Federal Election Commission, independent agency. They make policies. Suppose the president, whoever was the president, didn't like the fact they were investigating somebody who had contributed to him. Could he order them to stop that investigation?
Senator, I don't think I've ever said that. I don't think I've ever challenged the constitutionality of independent agencies. My understanding.
No, what you said, I want to make sure. My understanding is you chastised Congress for giving so much power to them when the power should be in the president or in the executive.
Senator, I don't think I've ever said that either. I said that I thought that there was merit to the theory of the unitary executive, and I tried to explain how I thought that should play out in the post-Morrison world, accepting Morrison as the Supreme Court's latest decision and a resounding 8-1 decision on the issue of removal. How should the concept of the unitary executive play out in the post-Morrison world? On the issue of removal, my understanding of where the law stands now is that Myers established that there are certain officers of the executive branch whom the president has the authority to remove as he sees fit. There are and there are those.
He could fire his whole cabinet today if he wanted to. I mean, don't we all accept that?
Well, that was the issue that was the issue that was presented by the Tenure in Office Act that led to the impeachment of the first President Johnson. And in Myers, Chief Justice Taft, although the act, that controversy was long past, Chief Justice Taft opined that the Tenure in Office Act had been unconstitutional.
But let's not go off the subject of these independent agencies. that we set up, using the example of the FEC, the Federal Election Commission, could the president, if he didn't like somebody they were investigating, a contributor or something, could he order them to stop?
What Morrison says is that Congress can place restrictions on the removal of inferior officers, provided that those removal restrictions don't interfere with the president's exercise of executive authority. So they adopted a functional approach, and that was the court's latest word on this question. They looked back to Humphrey's executor and Weiner, which had talked about categories, and they under categories of quasi-judicial and quasi-legislative officers, and they reformulated this as a functional approach, and that's the approach that would now be applied.
Do you believe the president has the power to curtail investigations, for example, by the Department of Justice?
I don't think
the Department of Justice is under him.
I don't think the president is above the law, and the president is the head of the executive branch, and I've explained my understanding of the removal restrictions that can and cannot be placed on officers of the executive branch.
But could he order them to stop an investigation?
Well, you'd have to look at the facts of the case and the particular officer that we're talking about.
Could he order the FBI to conduct surveillance in a way not authorized by statute?
The president is subject to constitutional restrictions, and he cannot lawfully direct the FBI or anybody in the Justice Department or anybody else in the executive branch to do anything that violates the Constitution.
Could he, I'm speaking now of statute, could he order our intelligence agencies to do something that was specifically prohibited by statute?
Well, my answer to that is the same thing. He has to follow the Constitution and the laws of the United States. He has to take care that the laws are faithfully executed. If a statute is unconstitutional, then the Constitution would trump the statute. But if a statute is not unconstitutional, then the statute is binding on the president and everyone else.
Well, does the president have unlimited power just to declare a statute, especially if it's a statute that he had signed into law, to then declare it unconstitutional? He's not going to follow it?
If the matter is later challenged in court, of course, the president isn't going to have the last word on that question, that's for sure. And the courts would exercise absolutely independent judgment on that question. It's emphatically the duty of the courts to say what the law is when constitutional questions are raised in cases that come before the courts.
Now, that's an answer I agree with. Thank you. So, in other areas, SEC, can he order them to stop an investigation if it's somebody doesn't want to investigate it?
Well, the independent agencies are governed by Humphrey's executor and the cases that followed that, and there have been restrictions placed on the removal of commissioners of the independent agencies, and they've been sustained by the Supreme Court. And that's where the Supreme Court precedent on the issue stands.
Is that settled law?
It is a line of precedent that culminated, I would say. There have been a few additional cases relating to this, the Edmund case and the Freitag case, but I would look to Morrison, which was an 8-1 decision involving a subject of considerable public controversy, the removal of an independent counsel, removal restrictions on an independent counsel.
Well, I'm still having some difficulty in statements you've made about the unitary form of government and how you would apply it. You said yesterday in answer to a question I asked that when people's rights are violated, they should have the day in court. The courts are there to protect the rights of individuals. I don't think anybody in this room would disagree with that. It's the practice we look at in PERG versus magnesium electron. You concluded the Congress didn't have the constitutional authority to authorize citizens to bring a suit against polluters under the Clean Water Act. Whether the people had justiciable claims or not, there were a number of people lived downstream from magnesium electron. They said the water had been polluted. They brought a suit. You threw it out. Judge Lewis dissented, said it should have gone back to the lower court on the question of facts. I'll give you a two-part question. One, why did you send that back? And do you accept laid law as being settled law?
Well, a magnesium electron presented the question of whether we had a case or controversy under Article 3, and that's the fundamental limit on our jurisdiction. The Supreme Court has said that we do not have a case or controversy before us if we do not have a party that has constitutional standing, which requires injury in fact. And the issue was whether the plaintiffs in that case had established injury in fact. There was a plant that was discharging certain things into a creek, which eventually emptied into the Delaware River, and the plaintiffs in the case alleged that they enjoyed the Delaware River in a variety of ways. They ate fish from the river, they drank water from the river, they walked along the river, but there was nothing in the evidence, and Judge Lewis agreed on this. Judge Roth wrote the opinion, I agreed with Judge Roth, and Judge Lewis agreed with this on this point. There was nothing in the record.
But didn't Judge Lewis agree with you on the legal point, but he suggested sending it back to the lower court to determine whether there were facts to give standing? I mean, we all agree you can't be in a case if you don't have standing, but didn't Judge Lewis say send it back to the lower court so they can determine on the facts whether there might be standing?
The evidence that was before us did not show that there was any standing on the part of the plaintiffs. They didn't. There was no evidence of harm to the Delaware River in any way from the discharges, and that was the basis of Judge Roth's opinion, with which I agreed. As I recall, Judge Lewis's point was that the case should go back to the district court so that the plaintiffs could have an opportunity to present additional evidence. But as I recall, they were not even arguing before us that they had additional evidence. They were not arguing before us, as I recall, that we have additional evidence and we like the opportunity to go back to the district court to present it. That's my recollection of the matter.
And the other part of my question is laid law, settled law?
Well, laid law is a precedent on the Supreme Court, and my answer to the question there is the same. It's entitled to the respect of stare decisis.
Thank you, Senator Leahy. Senator Hatch.
Well, Judge Alito, I just want to clarify a few matters. In his questioning this morning, Senator Durbin from Illinois, I think apparently misstated what Chief Justice Roberts said during his confirmation hearings. Senator Durbin claimed that the Chief Justice said that Roe was the settled law of the land. In fact, that exchange that Senator Durbin referred to was made during the confirmation process for Judge Roberts to the Circuit Court of Appeals for the District of Columbia, where he would have to admit that that would be settled law for him in that court. It's beyond question that for a Circuit Court nominee, the Supreme Court's pronouncements on specific questions are binding precedents and will be the settled law of the land. Moreover, contrary to the distinguished senator from Illinois' suggestion, then Judge Roberts' testimony in his recent confirmation hearing, and your testimony today and yesterday, you've both been entirely consistent in this particular matter. I just wanted to clarify that because there's a difference between a nominee for the Circuit Court of Appeals saying that something is settled law that he or she has to be bound by, than by somebody who is a nominee for the Supreme Court. And that's just a matter of clarification that I would like to make at this time. Now, yesterday you were asked I think some 340 questions by 15 senators, and you're getting a bunch today, and I'm told that you felt that you had to decline to answer only about 5% of them. That's even lower than previous Supreme Court nominees, by far, in most cases. Now, this hearing has hopefully provided an opportunity for you to address your concerns and to address our concerns and answer some of the criticisms from members of this committee. But of course, there's always a battle waged outside of this committee room by the special interest groups who are also making charges and launching really unfair attacks on you. Now, these attacks typically go directly across the airwaves or the internet with hardly a chance to even catch them, let alone address them or rebut them or correct them. So I want to give you a chance to, respond to some of these attacks by some of these left-wing groups, many of which are certainly less than responsible and in my view, pretty reprehensible in what they do in these matters. One group says in a press release that in the Chittister case and at other times in your career on the bench, you go out of your way to rule against workers. Now, this group claims what it calls your views and biases are strong evidence that you would, in their words, quote, rarely rule in favor of those seeking justice in the courts, unquote. Now, I think that's a good example of how misleading some of these groups can actually be, where they're looking only for results in certain cases rather than, upholding of the law itself in those particular cases. And they, in that particular case, they're apparently willing to ignore two things about the cases they discuss. They ignore the facts, they ignore the law, and that's all, just the facts and the law. But they also ignore what you've written. And they ignore what you've said here today. Well, how about that criticism, Judge? In Chittister, did you go out of your way to rule against workers? What were the facts and the law in the case, and why did you think that they required the result that you finally upheld in that case?
I thought the result was dictated by Supreme Court precedent, and I wasn't the only one who thought that. That was a unanimous decision of our panel, Judge McKee, and I believe Judge Fulham from the District Court in Philadelphia were on that panel. They all agreed, and it is my recollection that 7 other courts of appeals have decided the case the same way. More than 20 Court of Appeals that issue the same way. More than 20 Court of Appeals judges, including judges appointed by all recent presidents, have reached that decision. And I think when you look at the law and the facts of the case, it becomes clear why there is so much unanimity on the question. Whether one likes the test or not, the test that we on the lower courts have to apply in this area is the congruence and proportionality test from City of Bernie. Or what we had to do was to see whether there was a record of discrimination relating to the particular provision that was at issue in Chittister, which had to do with leave for personal illness. So there would have to be some evidence that state employers had given more leave for personal illness to men than women, or more leave for personal illness to women than men, and there was no evidence whatsoever on this issue, and that's why all of these courts of appeals reached the conclusion that they did in Chittister.
When somebody takes an unfair crack at me, I can come back at them as a member of the United States Senate, but because you're a judge and not a politician, you really don't have the opportunity really to address fully these misrepresentations of your views, and there have been plenty of them in this process that you've had to undergo. So I wanted to give you some opportunity here. For example, one liberal group sent an email around just yesterday that claimed you were not responsive to a question about whether the president can immunize executive branch officials who directly violate the law. Now, is it an accurate representation of your views to suggest that you argued that executive branch officials should be fully immunized for their violations of the law?
No, it's not a correct expression of my views. The president, like everybody else, has to follow the Constitution and the laws. He has to follow the Constitution at all times, and he has to follow all the laws that are enacted consistent with the Constitution. That's clear. Now, in the Mitchell versus Forsyth case, which that they may be referring to, that was simply, I was simply saying that a certain argument relating to immunity from civil damages was an argument that had been made before, and it was an argument that was being requested by our client in the case, who was being sued in his individual capacity, and I recommended that we not make the argument, but I said, I don't dispute this argument, and that's all that was involved there.
Okay, well, let me just say this. I want to allow you to respond to a tactic that has been used by several of our colleagues here in these hearings. They observe results in some past cases, and then they express concerns that entire groups or categories of litigants might not be able to get a fair shake by you in the court. One of them yesterday wondered whether the average citizen, quote, can get a fair shake from you when the government is a party, unquote. Another did the same thing this morning. It's one thing to express disagreement with your decisions, and of course, as I said before, to look only at results and ignore the facts and the law is fundamentally misguided, and it's a misleading way of evaluating judicial decisions. But let's be clear what is being floated around here with this type of tactic. Those who say because you ruled this way in the past, litigants cannot get a fair shake in the future are saying, Judge, that you're biased, that you prejudge these cases, that you are less than fair and impartial, something that virtually everybody who knows you, including all of the people who testified before the American Bar Association, say is false. That you prejudge these cases, you're less than fair and impartial. You know, that's a very serious charge. Even if it is cloaked in suggestions and innuendo. Now, Judge, you previously mentioned your oath of office, an oath before God to do equal justice to everyone without regard to who the parties are. How do you react to this suggestion that the way you've ruled in the past shows or even suggests that you're biased and that entire categories of litigants may not get a fair shake before you?
Well, I reject that. I believe very strongly in treating everybody who comes before me absolutely equal. I take that oath very seriously, and I've tried to my very best to abide by that during my 15 years on the bench. Now, I don't think a judge should be keeping a scorecard about how many times the judge votes for one category of litigant versus another in particular types of cases. That would be wrong. We're supposed to do justice on an individual basis in the cases that come before us. But I think that if anybody looks at the cases that I've voted on in any of the categories of cases that have been cited, they will see that there are decisions on both sides. In every type of employment discrimination case, for example, there are decisions on both sides.
Well, most employment discrimination cases really are decided at the lower level.
Most of them are,
And
yes.
when they get up to your level, it's generally decided on technical or procedural basis. Am I wrong in that?
No, that's correct, Senator.
And sometimes you have to uphold the law, even though you may be uncomfortable with the law yourself.
We have to decide the cases on the facts that are in the record and the law that applies.
Well, that's right. Well, let me just give you a couple of, let me just ask you about a few of your cases. Because, you know, it's easy to cherry pick these cases and find a sentence here you don't like and a sentence there you don't like and criticize you for in the process as though you're not being fair, when in fact everybody who knows you knows your impeccable reputation for fairness, dignity, decency and honor, and capacity. And that's why you got the highest rating from the American Bar Association, and deserve it. And you've twice got that. And I know how tough they can be. But let me just give you a couple illustrations. Zuby v. AT&T. You were the lone dissenter in that case. What did you dissent from?
I dissented from a majority decision that held that Mr. Zuby, who was claiming racial discrimination, would not have his day in court because of the statute.
Who would have given him his day in court, right?
I would have,
if it had been up to you.
Yes.
All right. How about U.S. versus Cathcart? I don't expect you to remember all these cases, but and if you don't, just raise your hand and I'll try and recite them. But this was a Fourth Amendment case. You held that the Fourth Amendment does not allow police to target drivers because of the color of their skin. Is that right?
That's right. That was essentially a case of racial profiling, and I wrote an opinion holding that that was a violation of the Fourth Amendment.
And that was even after a police officer received a report that 2 black men in a black sports car had committed 3 robberies. and she pulled over the first black man in a black sports car, the first black sports car she saw. But you ruled against the defendant, or ruled for the defendant and against racial profiling in that case.
That's correct, Senator.
Okay, and Thomas versus Commissioner of Social Security. Just to mention a few of these cases to show that you're going to do what's right, regardless. And sometimes in these employment cases and even other cases, when you get up on appeal, they're fairly technical in nature, and you've got to do what's right under the law. But in Thomas versus Commissioner of Social Security, do you recall that case?
I do.
What'd you do there?
Well, that was the case where I think the Supreme Court thought that my opinion had gone too far in favor of the little guy who was involved there.
This was a woman with disabilities, right?
That's right, a woman who was trying to
And
get
she sought Social Security benefits.
Social Security disability benefits, and in order to be eligible for those, she had to be unable to perform any job that existed in substantial numbers in the national economy.
She had a job as an elevator operator, if I recall.
That's right. As the case was presented to us, the only job that she could perform was her past job, which was as an elevator operator. And what I said was that you can't deny somebody Social Security benefits because the person is able to do a job that no longer exists in any substantial numbers in the national economy. You can't deny benefits based on a hypothetical job. It has to be based on a real job. And the Supreme Court didn't see it that way, but it seemed to me that the way that we ruled was consistent with what I thought.
In other words, although you stood up for the person seeking rights here, the Supreme Court overruled you.
That's right.
Oh, my goodness. In the landmark case of, how do you pronounce it, Fatton v. INS?
Fatton, I think.
Well, this involved an Iranian woman, Iranian women who refused to conform to their government's gender-specific laws and social norms, whether or not they should be granted asylum in America. How did you rule in that case?
I think that was one of the first cases in the federal courts to hold that requiring a woman to be returned to a country where she would have to wear a veil and conform to other practices like that would amount to persecution if that was deeply offensive to her, and that subjecting a woman to persecution in Iran or any other country to which she would be returned based on feminism would be persecution on the basis of political opinion.
Well, I've got another 9 or 10 cases, and perhaps even more, that I could go through. But the point is that whenever they deserve to win, they win, regardless of whether they're rich or poor, whether they're powerful or not. You've basically upheld the law in these cases. Is that correct?
That is what I've tried to do.
And where you've been in dissent, you've tried to do it to the best of your abilities.
That's right, Senator.
Okay. Let me just mention one other thing. I think you've got this business of the Vanguard. When you signed that back in 1990, 12 years before the matter for which you're being criticized, not by anybody who has any ethical, professorial, or other knowledge, not by the American Bar Association, not by the vast majority of lawyers who look at these matters, that particular statement said, "Will you, during your, quote, initial service," unquote. Seems to me those are important words. Now, you haven't tried to hide behind that. You've just honestly explained that basically you made a mistake, which really wasn't a mistake according to all the ethics people and according to the American Bar Association. And now, instead of the original accusation and the original implication, you're being accused of not being forthcoming because of that original statement in your application form to the committee questionnaire. But the fact of the matter is that, quote, initial service doesn't mean 12 years away, does it? When there's no chance in the world that you could ever have received any monetary benefit from Vanguard.
Well, I don't think initial service means 12 years away.
Neither do I, and neither does anybody who cares about justice and about what's right in this matter. So to blow that out of proportion like your adversaries have done is really pretty offensive. I could go on, but and maybe be stronger on that, but the fact of the matter is I just wanted to make that initial service, unquote, pretty clear. Now, let me just say that sometimes I just can't make sense out of what some of your critics are saying. On the one hand, they want to portray you as some sort of a robotic patsy for big government who does not think for himself. Yesterday, one of my Democratic colleagues even suggested that the Bush administration was trying to manipulate you to give responses favorable to them in this hearing. Now, you quite rightly said, and I think you were fairly restrained about saying it, that you've been a judge for 15 years and are quite capable of thinking for yourself. On the other hand, then your critics then turn it around and attack you for supposedly dissenting too much, as if you should actually stop doing all that thinking for yourself and just fall in line with the majority in all of your cases. Now, Judge, I know that appeals court judges, that the appeals courts themselves are collegial bodies, but how do you view dissenting from your colleagues? How do you decide when to do it? How do you know how often you dissent in your court, and or do you know how often you dissent in your court, and whether it's out of step with your colleagues? Could you give us some answers there?
Yes, I think that it's important for a multi-member court to issue a judgment and to speak clearly to the lower courts and the parties. And so when I've been in a position where taking an independent position would result in the absence of a judgment, I have gone out of my way to make sure that there was a judgment, that there was a majority opinion. And an example of that is the RAPA case, where we were really divided three ways. And my position was close to to Judge Becker's opinion, and Judge Becker had the opinion writing assignment. And I issued an opinion saying, I don't completely agree with the way Judge Becker analyzed this issue. I would analyze it differently, but I'm joining his opinion so that there is a majority opinion, so that there's a clear statement of the law for the guidance of the parties. I think that's the first principle. A second is that judges should be respectful of each other's views, and I don't have any, I have tried never to write a dissenting opinion or respond in a majority opinion to a dissenting opinion in a way that was not completely respectful of the views of the other members of the court. It's useful to dissent if there's a chance that the case may go en banc, and that's happened in a number of cases where I've dissented. It's useful to dissent if there is a chance that the case may go to the Supreme Court, and so that the Supreme Court will have the benefit of a different expression of views. And there have been cases.
Would it surprise you to know that you've dissented only 79 times in nearly 5,000 cases in which you've participated? That comes out to about 1.6%, which is considerably lower than most others who have been on the appellate courts. And I would observe that the Washington Post concluded in an editorial that your dissenting opinions, quote, are the work of a serious and scholarly judge whose arguments deserve respect, unquote. I certainly agree wholeheartedly with that assessment. Thank you, Mr. Chairman.
Thank you, Senator Hatch. Senator Kennedy.
Thank you very much, Mr. Chairman. Judge Alito, I hadn't planned to get into Vanguard on this particular round, but I chaired those hearings when you were promoted to the circuit court, and I was also the one that filed those questions, which you responded to. And you responded under oath when you promised the committee that you would recuse yourself on Vanguard issues. Now I'm just hearing from you that you believe that that pledge was somehow conditioned. I'm unlike my friend, and he is my friend from Iowa, that says, well, a pledge is just a pledge. It's like any political pledge it is around here. It's a political promise and doesn't carry much weight. That's not my opinion, and I don't think it is the opinion of most of the members of this body. You made a pledge to the Senate, effectively, to the American people, that you're going to recuse yourself. Now you say, well, it was just for an initial time, and I think 12 years is more than I really had in mind, or you just qualified your answer. How long, when you made that pledge and that promise to the committee, how long did you intend to keep it?
Well,
and when that time was up, did you ever imagine that you might get back to the committee and said, I believe my time is up on Vanguard?
Well, Senator, the statement that the nature of the question that I was responding to did not figure in the way the manga case was handled, and I thought I made that clear yesterday. I was following throughout my time on the bench the practice of going beyond the code, and had I focused on this issue when the matter came before me, I would have recused myself at that time, as I later did. But in answer to Senator Hatch's question, looking at that question today and looking at the answer, the question was, what do you intend to do during your initial period of service? And I think that that's what the answer has to be read as responding to. But let me just to be clear, that was not, I'm not saying that that's why this played out the way it did. I'm just saying that's how I think the question and the answer, that's how I think the question and any response to the answer by any nominee needs to be interpreted.
Well, if there's someone that can just understand what you just told us, I'd be interested in it, because I don't.
Well, I'll be glad to explain it.
Mr. Chairman, you, are, in response to Senator Hatch, did not believe that you were bound by the promise because you said in your mind, or you felt that it was just for the initial aspects of it. That's another issue, because initially was meant to include the investments that you had at that particular time. You might have those investments and then discard an investment and therefore no longer have a conflict. That is what, as the asker of the question had intended. But you've added another wrinkle to it. You've just indicated that when you made a pledge to the committee that you were going to recuse yourself, that you thought that at some time you were going to be released. And I'd just like to know how long that was going to be. Was that going to be 2 years? Was it going to be 3 years? Was it going to be 5 years? When did you feel that you were going to be released?
Well,
If
Senator,
that was it, if we followed your interpretation.
Senator, I did not rely on that time limitation in relation to what I did in the manga case, and I hope I've made that clear. If I didn't in my previous answer, I do want to make it clear. I did not rely on that in my handling of the manga case. Looking at the question now, where it says initial period of service, I would say that 12 years later is not the initial period of service, but that was not.
When did it stop then? When did you think that your pledge to the committee halted? After how many years? 6 months?
Well, Senator,
what did you intend at the time that you made the pledge? What was in your mind at that time? I'm interested in what's in your mind at this time, but what was in your mind at that time?
I can't specifically recall what was in my mind at that time, but I'll tell you what I'm pretty sure I had in mind. I was not a judge, and I was being considered for a judicial position, and what I was trying to express was basically the policy that I followed during all my years on the bench, which is to bend over backwards to make sure that I didn't do anything that came close to violating the code of conduct or give anybody the impression that I was doing anything that was improper.
My last question on this is, how long then, when you made the promise under oath to the committee that you were going to recuse yourself, and you understand that now to be, in your own interpretation, just to be the initial time, how long did you think that that pledge and promise lasted?
Senator, as I said, and Senator, as I said, I can't tell you 15 years later exactly what I thought when I read that question. It refers to the initial period of service, and looking at it now, it doesn't seem to me that 12 years later is the initial period of service.
Well, my question to you, which I guess I'm not going to get an answer to, is when did it? Is 10 years? How about 3 years? Is that?
Well, I don't know exactly what the time limitation would be, but 12 years does seem to me not to be the initial period.
We'll come back. I just want to mention, in fairness to my friend and colleague, both my friends, Senator Hatch and Senator Durbin, in Senator Hatch's quoting of Senator Durbin, that you responded on the question of the Roe v. Wade in the when you were the circuit court. I have here the record that said of the hearings of Roberts. And the question was asked by Senator Specter to Judge Roberts during the time of his consideration for the Supreme Court. So I want that to be, Senator Durbin can clarify the record, but I wanted that to be clarified so that there wasn't a confusion about it. Now, in the time that I have, Judge Alito, I listened carefully to responses that you gave to Senator Leahy about the CAP organization at Princeton. And I listened to other responses that you gave to our colleagues, and again, did Senator Durbin earlier today. But I have just some questions on this to at least try to finalize, at least in my mind, and it might be useful in the committee's mind as well. You had indicated in your 85 job application that you're a member of the Federalist Society for Law and Public Policy and a regular participation at its luncheon, and a member of the Concerned Alumni at Princeton University, a conservative alumni group. And you said yesterday that you racked your memory about the issue and really had no specific recollection of the organization. Is that correct?
I had no specific recollection of joining the organization.
And you also said yesterday and today to Senator Durbin that you very likely joined CAP because of your concern over the ROTC program being kicked off campus. Is that correct?
Well, what I said specifically was that I racked my memory as to why I might have joined, and the issue that had bothered me for a period of time as an undergraduate and in the 80s, around the time of this, when I made this statement, was the issue of ROTC. This was the issue about the administration of Princeton that bothered me. I had a high regard for Princeton in many respects, in general, and have participated in a lot of their activities. But this issue bothered me a great deal at various times, and that's what I said.
And finally, you said yesterday that you very likely joined CAP around 1985, just before you were applying to the high-level job in the Justice Department under President Ronald Reagan. I think that's correct.
Senator, what I specifically said, as I recall, is that if I had done anything substantial in relation to this group, including renewing my membership, I would remember that, and I do not remember that.
So I want to ask a few things that I hope can clear this up. You have no memory of being a member. You graduated from Princeton in 1972, the same year CAP was founded. You call CAP a conservative alumni group. It also published a publication called Prospect, which includes articles by CAP members about the policies and that the organization promoted. You're familiar with that?
I don't recall seeing the magazine. I might have seen it at some point.
Did you know that they had a magazine?
I've learned of that in recent weeks.
So a 1983 Prospect essay titled "In Defense of Elitism" stated, quote, "People nowadays just don't seem to know their place. Everywhere one turns, blacks and Hispanics are demanding jobs simply because they're black and Hispanic. The physically handicapped are trying to gain equal representation in professional sports, and homosexuals are demanding that government vouchsafe them the right to bear children." So, did you read that article?
Finish the last line.
Finish the last line is, and homosexuals are...
And now, here come women.
If the senator let me just...
Yes,
Can I get 2 more minutes from my friend? Just to continue along, I apologize, Judge. Did you read this article?
I feel confident that I didn't. I'm not familiar with the article, and I don't know the context in which those things were said, but they are antithetical.
Well, could you think of any context that they could be in?
It's hard to imagine if that's what anybody was endorsing. I disagree with all of that. I would never endorse it. I never have endorsed it. Had I thought that that's what this organization stood for, I would never associate myself with it in any way.
The June '84 edition of Prospect magazine contains a short article on AIDS. I know that we've come a long way since then in our understanding of the disease, but even for that time, the insensitivity of statements in this article are breathtaking. It announces that a team of doctors has found that AIDS virus in the rhesus monkeys was similar to the virus occurring in human beings, and the article then goes on with this terrible statement: "Now the scientists must find humans, or rather homosexuals, to submit themselves to experimental treatment. Perhaps Princeton's Gay Alliance may want to hold an election. You didn't read that article.
I feel confident that I didn't, Senator, because I would not have anything to do with statements of that nature.
In 1973, a year after you graduated and during your first year at Yale Law School, former Senator Bill Bradley very publicly disassociated himself with CAP because of its right-wing views and unsupported allegations about the university. His letter of resignation was published in the Prospect, garnered much attention on campus and among the alumni. Were you aware at the time of that at the time that you listed the organization in your application?
I don't think I was aware of that until recent weeks when I was informed of it.
And in 1974, an alumni panel, including now Senator Friss, unanimously concluded that CAP had presented a distorted, narrow, hostile view of the university. Were you aware of that at the time of the job application?
I was not aware of it until very recently.
In 1980, the New York Times article about the co-education of Princeton, CAP is described as an organization against the admittance of women. In 1980, you were working as an assistant U.S. attorney in Trenton, New Jersey. Did you read the New York Times? Did you see this article?
I don't believe that I saw the article.
And did you read a letter from CAP mailed in 1984? This is the year before you put CAP on your application, to every living alumni, so I assume you received it, which declared, Princeton is no longer the university you knew it to be. As evidence, among other reasons, it cited the fact that admission rates for African Americans and Hispanics were on the rise, while those of alumni children were failing, and Princeton's president at a time has urged that the then all-male eating clubs to admit females. And in December 1984, President William Bowen responded by sending his own letter. This is the president of Princeton, responded by sending his own letter to all of the alumni, in which he called CAP's letter callous and outrageous. This letter was the subject of a January 1985 Wall Street Journal editorial congratulating President Bowen for engaging his critics in a free and open debate. This would be right about the time that you told Senator Kyl you probably joined the organization. Did you receive the Bowen letter, or did you read the Wall Street Journal, which was pretty familiar reading for certainly a lot of people that were in the Reagan administration?
Senator, I've testified to everything that I can recall relating to this, and I do not recall knowing any of these things about the organization, and many of the things that you've mentioned are things that I have always stood against. In your description of the letter that prompted President Bowen's letter, there's talk about returning the Princeton that used to be. There's talk about eating clubs, about all-male eating clubs. There's talked about the admission of alumni children. There's opposition to opening up the admissions process. None of that is something that I would identify with. I was not the son of an alumnus. I was not a member of an eating club. I was not a member of a eating facility that was selective. I was not a member of an all-male eating facility, and I would not have identified with any of that. If I had received any information at any point regarding any of the matters that you have referred to in relation to this organization, I would never have had anything to do with it.
You think that these are conservative views?
Senator, whatever I knew about this organization in 1985, I identified as conservative. I don't identify those views as conservative. What I do recall as an issue that bothered me in relation to the Princeton administration as an undergraduate and continuing into the 1980s was their treatment of the ROTC unit and their general attitude of toward the military, which they did not treat with the respect that I thought was deserving. The idea that it was beneath Princeton to have an ROTC unit on campus was an offensive idea to me.
Just moving on, you mentioned, and I only have a few minutes left, you joined CAP because of your concern about keeping ROTC on campus. Now, ROTC was a fairly contentious issue on Princeton campus in the early 70s. The program was slated to be terminated in 1970 when you were an undergraduate. By 1973, 1 year after you graduated, ROTC had returned to campus and was no longer a source of debate. And from what I can tell, by 1985, it was basically a dead issue. In fact, my staff reviewed the additions of prospects from 1983 to 85 and could find only one mention of ROTC, and it appears in a 1985 issue released for homecoming that year that says ROTC is popular once again. Here is the prospect, 1985, ROTC is popular again. This was just about the time that you were submitting this organization in your job application.
Senator, I'm sorry.
No, briefly, please.
It's my recollection that this was a continuing source of controversy. There were people on the campus who, members of the faculty, as I recall, who wanted the unit removed from the campus. There was certainly controversy about whether students could get credit for courses, which I believe was a military requirement for the maintenance of the unit. There was controversy, as I recall, about the status of the instructors, whether they could be given any kind of a status in relation to the faculty. I don't know the exact dates, but it's my recollection that this was a continuing source of controversy.
Well, Mr. Chairman, my time is running out. I had wanted to just wind up on a few more brief questions on this, but I have to say that Judge Alito, that his explanations about the membership in this sort of radical group and why you listed it on your job application are extremely troubling. In fact, I don't think that they add up. Last month, I sent a letter to Senator Specter asking a number of questions about your membership in CAP. I asked Senator Specter to make a formal committee request for the documents in the possession of the Library of Congress as part of the William Rusher papers. Mr. Rusher was the publisher of the National Review, was an active founder and leader of CAP. Do you have any hesitancy or reason for us not to look at those documents?
They're not my documents, Senator, and I have no
You think they would be helpful
about
to
it
us
whatsoever.
You think they'd be helpful?
Senator, I don't believe I had any active involvement with this group.
Well,
I've racked my memory, and I can't recall anything. And if I had been involved actively in any way in the group, I'm sure that I would remember.
Well, Mr. Chairman, if I could have your attention, I think we ought to vote on issuing a subpoena to the custodian of those CAP records. And I want to do that at an appropriate time. I'd move that the committee go into executive session for the purpose of voting on the issuancing of the sole purpose for issuing the subpoena of those records.
Well, we'll consider that, Senator Kennedy.
Well,
There are many requests which are coming to me in many quarters, and quite candidly, I view the requests, if it's really a matter of importance. You and I see each other all the time. You've never mentioned it to me, and I do not ascribe a great deal of weight. We actually didn't get a letter, but
you did get a letter, are you saying?
well, now wait a minute. You don't know what I got. I'm about to.
Of course I do, sir, Senator, since I sent it.
Well, the sender
I've got
doesn't
it right
necessarily
here.
know what the recipient gets, Senator Kennedy.
I've got it right here.
You are not in the position to say what I receive. If you'll bear with me for just 1 minute.
But I am in a position to say what I sent to you on December 22nd.
Well, you're in a position to tell me what you sent.
I renew my request, Senator, and if I'm going to be denied, then I'd appeal the decision of the chair. I think we are entitled to this information. It deals with the fundamental issues of equality and discrimination This nominee has indicated he has no objection to us seeing these issues. We've gone over the questions, and we are entitled to get that kind of information. And if you're going to rule it out of order, I want to have a vote on that here on our committee.
Well, don't be premature, Senator Kennedy. I'm not about to make a ruling on this state of the record. I hope you won't mind if I consider it, and I hope you won't mind if I give you the specifics that there was no letter which I received. I take umbrage that you're telling me what I received. I don't mind you're telling me what you mailed. But there's a big difference between what's mailed and what's received, and you know that. We're going to move on now.
Well,
Senator Grassley?
Mr. Chairman, I'd appeal the ruling of the chair on this.
There's been no ruling of the chair, Senator
Well, what
Kennedy.
is my request is that we go into the executive session for the sole purpose of voting on a subpoena for these records that are held over at the Library of Congress for that purpose and that purpose only. And if I'm going to be denied that, I'd want to give notice to the chair that you're going to have it again and again and again, and we're going to have votes of this committee again and again and again until we have a resolution.
Well, Senator Kennedy, I'm not concerned about your threats to have votes again, again, and again. And I'm the chairman of this committee, and I have heard your request, and I will consider it. And I'm not going to have you run this committee and decide when we're going to go into executive session. We're in the middle of a round of hearings. This is the first time you have personally called it to my attention, and this is the first time that I have focused on it. And I will consider it in due course. And now we'll move to Senator Grassley for 20 minutes.
Well, we've gone over the same ground many times. I suppose maybe to some extent both sides are guilty of that. But we have an old saying in the Midwest about if a horse is dead, quit beating it. And I think several horses have been beaten to death, particularly on the other side. And you've been very consistent in your answers, and I thank you. And I think that that speaks to the intellectual honesty of your positions. It's kind of like we're in the fourth quarter of a football game, and you're the quarterback, and your team is way ahead here in the fourth quarter, and opponents are very desperate, trying to sack you and aren't doing a very good job of it. And they haven't hit you all day, now for 2 days, and you're going to keep getting these last minute Hail Marys thrown at you, so just to bear with us. I want to compliment you, first of all, before I ask some questions, and I just did to some extent about the consistency of your testimony, but I think it's been good. I think under very difficult circumstances, you've handled yourself very well, being responsive, forthright, thoughtful. I sense in you a person that's very sincere, and obviously I don't know you except this appearance here and the small period of time we spent in our office. Seems like you have modesty that's a breath of fresh air, demonstrating a command of and very much a respect for the law and the Constitution, of course. And this is all stuff that we ought to be looking for in the tradition of Alexander Hamilton saying the role of the court or the Senate is to make sure that only competent people get on the court and that political hacks don't get on the court. And you're surely no political hack, and you're very competent, and that's been demonstrated with your fair and open-minded approach to your being a judicial person. It's too bad that we're getting this misconstruing of your record or the answers, the claim that you've not written a single opinion on the merits in favor of a person of color alleging race discrimination on the job in your 15 years on the bench. I've looked at a lot of opinions you've given, and it's just not true. Your record shows that you ruled in favor of minorities, making allegations of racial discrimination in employment, not once, but in a number of cases. The claim that you acted unethically in the Vanguard case is just not true. You did nothing improper and actually went beyond the rule to ensure compliance. The claim that you would support an unchecked executive is just not true. Your record shows that you've repeatedly ruled against the government and that you've told us no one, including the president, is above the law. The claim that you've ruled in vast majority of time against the claims of individual citizens in favor of the government and large corporations is just not true. The reality, as I see it, that you found in favor of the little guy in numerous cases, but because of who was right and who was wrong, not just because you got a bias one way or the other. Your critics are, I think, grasping at any straw to tarnish your record, and that's unfortunate. Judge Alito, in your opening statement, you said, and I hope I quote you accurately, no person in this country, no matter how high or powerful, is above the law, and no person in this country is beneath the law. You didn't go into detail about what you meant. I think it's quite clear, above the law, but give us that diverse opinion, above the law versus beneath the law.
Every person has equal rights under the law in this country, and that involves people who have no money. That includes people who have no money. That includes people who do not hold any higher or prestigious position. It includes people who are citizens and people who are not citizens. Everybody is entitled to be treated equally under the law, and so and I think that's one of the greatest things about our country and about our legal system.
You've been criticized for being hostile to voting rights based upon a statement that you wrote 20 years ago when you were applying for a job with the Justice Department during the Reagan years. In fact, yesterday, some of my colleagues repeated that assertion, but it's apparently to me that it's off the mark. Specifically, in your '85 statement, you wrote that you became interested in constitutional law and went to law school in part because you had some disagreements over Warren Court decisions, including some regarding reapportionment. Of course, that's understandable because the Warren Court had handed down very many decisions on reapportionment, and they had been criticized as unworkable, and that, in fact, the Supreme Court backed away from some. So there was disagreement, there was debate over those issues at that time, probably a lot less today, but still recently there's going to be a case going to the court. Some have questioned your 1985 statement regarding electoral reapportionment, that is how districts are drawn. They suggested that you're hostile to the principle of one person, one vote. Clarify for me, nowhere in your '85 statement did I find that you wrote that you ever disagreed with the principle of one person, one vote, did you?
I never disagreed with that principle, Senator. What I disagreed with when I was in college was the application of the principle in some of the elaboration of the principle in some of the late Warren Court decisions. And this grew out of my father's work with the New Jersey legislature. He had been the secretary to the State Constitutional Convention of 1966, which redrew the provisions of the state constitution relating to the composition of the legislature in an effort to bring it into compliance with the one person, one vote standard. The effect of these provisions, however, because they tried to respect county and municipal lines, as I recall, resulted in population deviations of under 10%, but those deviations were much higher than the ones that the Supreme Court said in the late decisions that I'm talking about would be tolerated regarding congressional districts. There was a belief that that principle would be applied across the board, both to congressional districts and to legislative districts, and that would have wiped out the plan that had been adopted. And I was quite familiar with all of this, and it seemed to me an instance of taking a good principle, which is one person, one vote, and taking it to extremes, requiring that districts be exactly equal in population, which did not seem to me to be a sensible idea.
Isn't it true that the statement or the words "one person, one vote" weren't even in your statement?
Those words are not in my statement.
Well,
And
just
I
to
would
make-
just
Go
add,
ahead.
Senator, that this issue of how nearly exact the districts had to be was an issue that was working its way to the Supreme Court, or maybe it had actually been there, I've forgotten the exact chronology, at the time of the 1985 statement in Karcher versus Daggett, which involved the New Jersey Congressional Districting Plan.
Well, just to make sure that there's no lingering confusion then, let me ask you straight out, do you believe in the principle of one person, one vote?
I do. I think it's a fundamental part of our constitutional law.
I find it curious that the same people who are questioning your integrity are either asserting or implying that you took a position against the principle of one man or one person, one vote, when it is demonstrably false that you ever did. Further, on another point, some have suggested that you're hostile to women and minorities. Obviously, I don't think that's the case. I think you demonstrated that sincerity in just very recent statements today. Now, in the Washington Post article, there was Alberto Rivas, a criminal defense lawyer and a Democrat, said you, quote, took steps to diversify an office. This was when you were U.S. Attorney. You took steps to diversify an office that had a reputation as something of a white boys club. Rivas said that when you hired him at the U.S. Attorney's Office, New Jersey, he was the only Latino lawyer in the office, and by the time you left that office, Rivas said there was 4 Latino lawyers as well as African-American lawyers. Your commitment also included advancing women attorneys and promoting them into senior positions during your tenure as U.S. Attorney. And I understand that when you stated or started in that office, only 2 of the 15 divisional leadership attorneys, chiefs or deputy chiefs or attorneys in charge, were women, and 2 years later, you had more than double that number, and 5 of the 17 divisional leadership attorneys were women. Now, on the federal bench, you've hired many women and minorities to serve as law clerks, and you had a discussion with Senator Brownback earlier, mentioning some very complimentary things that Kathy Fleming, your former deputy chief and acting chief of special prosecutions units in the New Jersey office, and David Walk, a former lawyer in that office, had to say about you and your treatment of women and minorities. They both, being lifelong Democrats, vouched in those statements for your qualities as a judge and your respect for individual rights. And Mr. Chairman, if these letters, and they may have already been put in the record, but if they aren't in the record, I'd like to have those put in the record.
Without objection,
Yeah.
they will be made a part of the record.
Yeah. Several of your dissents have been referred to today, or not in the last 2 days, and so I wanted to comment on this suggestion that you're way out of the mainstream because you've written a lot of dissenting opinions. I don't find that you've written so many as a percentage of your total thing, but whatever reason you did it with good reason. But judges disagree all the time, and that's to be expected, and obviously there's nothing wrong with that. And in fact, the Supreme Court has agreed with your dissents on several occasions. I recall from reading synopsis of your opinions. And the reality is, as I see it, you don't disagree with majority opinions more frequently than most federal appeals judges do in similar cases. And of more than 4,800 cases, and that is an that we got from the Washington Post, but of more than 4,800 cases that you decided during your tenure on the Third Circuit, you dissented only in 79 cases, which would be only 1 6/10% of all those cases. So, you know, I don't think that there's anything very extraordinary about the number of dissents or the dissents, and particularly when the Supreme Court has agreed with your opinion in reversing the Third Circuit. I'd like to go to the issue of some historical basis for our constitutional law. The role of historical precedent in constitutional laws I find very interesting. For example, qui-tam lawsuits have been a feature of Anglo-American law since the Middle Ages and have been a common feature of federal statutory law even since the first Congress. Yet their constitutionality has never been clearly adjudicated by the Supreme Court. What role does long-standing historical practice play in assessing the constitutionality of a government act or practice?
Well, it can be very relevant in many instances. One place where this has come up is when a statute was passed by the first Congress, and this has happened in a number of occasions. The first Congress, which was responsible for the Bill of Rights, passed a number of statutes relating to provisions of the Bill of Rights, and the Supreme Court has often looked to those and said, this is the same Congress that proposed the Bill of Rights, and they did this in enacting a statute, so that gives us a good indication of what they had in mind. And when there's been a legal practice that's existed for that predated the Constitution, then that certainly is relevant in considering its constitutionality.
I'd like to have you think about legislative history and how you might use it, or how often you might use it, or even how often, maybe if you got a rough quantifiable answer, how often you might use it. The Supreme Court, I think, has quite often stated legislative history of a particular bill would be critical in their interpretation of it. What's your position with respect to legislative history? How is it, how important is it to you, and how have you utilized history in interpreting statutes?
I have often looked to legislative history in the cases that I've written concerning statutory interpretation. I think if anybody looks at those opinions, they will see that. When I interpret a statute, I do begin with the text of the statute. I think that certainly is the clearest indication of what Congress as a whole had in mind in passing the statute. And sometimes the language of the statute is dispositive, and it's really, the decision can be made based on the language of the statute itself. But when there's an ambiguity in the statute, I think it's entirely legitimate to look to legislative history, and as I said, I have often done that. I think it needs to be done with caution. Just because one member of Congress said something on the floor, obviously that doesn't necessarily reflect the view of the majority who voted for the legislation. So it has to be done carefully, and I think with a realistic evaluation of the legislative process. But I'm not one of the judges who thinks that you should never look to legislative history. I think it has its place.
Are you familiar with the legal arguments that some opponents of the False Claims Act have made to the effect that its qui-tam provisions are unconstitutional under Articles 2 and 3? And if you do you have any opinion on those arguments that are used without prejudicing any review of it you might give?
Well, the issue hasn't come up before me. I have a little bit of familiarity with the arguments, and I think that all I can say on the question is that the qui-tam statute is of historical origin, as you pointed out, and we have seen what it has produced in terms of tangible results in the cases that have been brought under the statute in recent years. And should an issue relating to its constitutionality come before me, either on the Third Circuit or the Supreme Court, then I would have to follow that whole judicial process that I've described and evaluate the arguments, and certainly study the question much more thoroughly than I have done up to this point.
Yeah, you may have just answered this question, but I'd like to get it explicitly on the record. have you ever written or spoken publicly about the issue of the constitutionality of QI-TAM or any other provision of False Claims Act? And if so, the circumstances and the context?
I'm quite sure I've never written or spoken about its constitutionality.
Do you feel that you have any bias against False Claims Act or Whistleblower Protection Act that would impact the ability of you to fairly decide cases involving that issue, those issues?
I certainly don't, Senator.
I'd like to ask you about the opinion you authored in Mystic. As author of the legislation that we call the False Claims Act, it's returned billions of dollars to the federal government and has become a very effective tool in combating fraud against the American taxpayers. So I follow court cases on this as much as I can. The False Claims Act contains a provision that jurisdictionally bars lawsuits based on public disclosure, including such things as administrative reports and investigations. The purpose of this provision is to prevent an individual who has read about a description of a fraud in a newspaper report, public document, government report, from simply taking that material and using it as a basis for a case. In Mystic, the QI-TAM relator had made a FOIA request and utilized some of the documents he received in response to FOIA in filing that that QI-TAM case. Your opinion, you determined that the QI-TAM relator had based his False Claims Act lawsuit on public disclosure made in an administrative report or investigation. To come to that conclusion, you had to equate that the QI-TAM relator, who was acting on behalf of the government, as the public. But I think it's clear that Congress did not equate such QI-TAM relators with the public when it wrote the public disclosure bar provision. That's because if Congress had done so, then everything QI-TAM relators know is known to the public, which doesn't make any sense. So, because my time's run out, I don't want to go on with a question, but you see what I'm getting at? Could you react to that?
I do, and I understand that's a very strong argument. I remember that I found that a very difficult issue to deal with, and I spent a lot of time on it, and my view of the matter elicited a strong and a very persuasive, I think, dissent by one of my colleagues, and so it's a tough issue, and if that were to come up again, I would have to really reconsider it.
You gave, just in your last sentence, you gave pretty much the same answer that Judge Roberts did. He had dissented in a case too, and it kind of worries me when we get two of you on the court that may have an unfamiliar with congressional intent on false claims. Thank you very much.
Thank you, Senator Grassley. That will be all. We'll recess until 2 o'clock.
Mr. Chairman, could
Yes, Senator Kennedy.
Just as a quick matter of personal privilege, I'd like to include in the record the response from your staff to this letter that I wrote to you on the 22nd, and also my staff response to your staff's response to the letter. Include them in the record.
Like all requests, unanimous consent for the record, they're granted.
Mr. Chairman,
Senator Durbin?
Mr. Chairman,
I just want it known that we're now into the lunch hour, but go ahead, Senator Durbin.
Mr. Chairman, I sent you a note and you were kind enough to come and speak to me about it. I've just asked for 2 minutes' time to respond to comments made by members of the committee mentioning my name after I asked questions this morning. You've asked if I would wait until Senator Coburn returned to the committee, and in deference to the respect to my colleague, I will do that.
Could I also, Mr. Chairman, on this
Well,
regard?
I appreciate it very much. Waiting for Senator Coburn, I think it is a good practice when comments are made about other members to do it while they're here or to ask their joinder. And that's why, if you have something to say to Senator Coburn, I want him here. Otherwise, he'll have something to say and you're not here.
In fact,
He
if
did
I
already,
might-
Mr. Chairman.
Now Senator Leahy
Oh,
is
well,
recognized into the lunch hour.
Into the lunch hour. Mr. Chairman, if I might, I came very close to objecting when Senator Coburn was speaking and referring to Senator Durbin. Senator Coburn is he's a valued member of the committee, of course, but new, and but I really think I've been here for 30 years. I've always made a point, if I'm going to raise something, to get word to the other other party. I think it's a good way of doing it, and you have been totally fair in that. And I would urge senators, if we're going to start quoting each other, that maybe we have a quote time or something like that. Senator Durbin's absolutely right and want to be able to respond to what was said.
Well, I think that we might agree on best practice, but when you deal with senators, my view is to give senators great latitude as to what they want to undertake to do. And if Senator Coburn wants to make a comment without Senator Durbin here, I think that's going to be his call, although my preference would be to the contrary. But when Senator Durbin wants time to respond, I immediately sent word to him he would have the time that he requested, and then I sent for Senator Coburn. And Senator Coburn's in a meeting that he couldn't leave, but we'll get the two of you together fairly promptly.
Thank you.
Lunchtime.
Now we're getting lunch.
He wanted me to see you, Pat. Okay. He insulted me before. Let's see now.
Doing great. Good things to come.
She's got voting here. Yeah,